Good morning, colleagues. Can you hear my voice? Can we have the thumbs up? We just want to check the sound. Thank you so much. We'll start in 1 minute. I see, Barbara Thorne, you cannot hear me. So you can't even hear if I say restart your machine. I will try to type for you and respond because you can't hear me. And Shamin as well, she can't hear me. I'll send them a message on the chat. Good morning, M&As and practitioners. Welcome to today's webinar. We are pleased to have you join us and discuss managing agent registration topic and the deregistration of property practitioners. The webinar is in coordination with Ms. Vanida Moodley from NAMA. They are one of our stakeholders. This webinar is part of our ongoing commitment to keeping our stakeholders informed, trained, or rather educated with regular updates and compliance. Today's discussion will unpack the process, requirements, fee structures, and obligations around the registrations and deregistration, particularly managing agents under the PPA Act. We know it's still a young legislation that we're trying to navigate on. We encourage active participation, so please feel free to use the Q&A function throughout the session. All participants' microphones will be off for now to avoid background noise so that we can finish for Advocate to give a presentation. Please use the chat box to post your questions or comments during the session, but we will address those after the presentation. Recording will be, we're going to record the session, and the recording will be posted on our PPRA TV within 48 hours. It's on our YouTube channel. Please subscribe. So today's presentation is done by Advocate Deborah Weil. We know we've attended most of her webinars. I think she's done more than 10, since last year. Advocate Weil is the Executive Manager of the Licensing and Exemptions Department at the PPRA, and she's also Fidelity Fund Claims Manager acting. Can we please welcome Advocate Weil as she take us through. Advocate, that's the first slide. You can unmute yourself. Let's start the presentation, and I will respond to everyone on the chat who can hear the sound. Let's test your sound, Advocate, if they can hear you.
Good morning, everybody. Welcome, practitioners, NAMA, and all those interested parties who are joining us today. Everybody hear me? I see plenty of thumbs up.
Yes, they can hear you.
Wonderful.
Thank you.
Thank you. Right, thank you very much, everybody. Nice to be with you. We're talking about regulatory changes in property practitioners and the PPA particularly. Some of you will be familiar with some of the slides I will look at, others are new. We're just going to give you some background as to the new Act, what the important aspects are for those of you who are property practitioners in the managing agent space, who may not be familiar with the regulatory framework that we've always had for property practitioners in the estate agent industry, and which now is extended to all property practitioners. So the first slide just deals with regulation and why it's necessary, what the purpose is to regulate. And I think regulation itself is not simply for the fact of regulating. It's not simply to be able to say, right, you can do this or you can't do that. The purpose of regulation is to ensure that everybody is treated fairly in a particular industry, that there is a certain standard that is maintained by people who operate in that industry, and that people can be free and at peace to rely on the information and the services that they receive in any particular industry. The particular purposes of regulation.
Excuse me, Advocate. I'm
Yes.
so sorry to do this to you. A lot of the colleagues on the chat, they cannot see your slide. Can we remove it and try to put it back again?
Okay, sure.
Maybe it's a refresh. I see it's a number of quite a number of people.
Okay, I'll do that. Can everybody see the slides now?
Yes, they can now see the slides. Thank you.
Okay, thank you. All right, let's move on to regulation. So we were talking about regulation in the industry and the purpose, which is to ensure compliance with the legislation that governs you, to also ensure education of those practitioners who are going to provide services in their particular industry. Transformation is important for our Act. It's one of the mandates that the Property Practitioners Regulatory Authority has, and needs to ensure that we maximize as far as possible. And of course, consumer protection is the last one. The legislation we dealt with previously was the Estate Agent Affairs Act, and that only governed estate agents. And it has now been replaced by the Property Practitioners Act, which deals with all property practitioners in all industries. And we now regulate not only estate agents, but 11 other industries as well, which we'll look at in a moment. It's important for newcomers to a regulated environment to realize that compliance with legislation is peremptory. It's essential, it's required, and failure to comply can cause us all sorts of problems, including disciplinary action and in some cases, even criminal action. So legislation is there for us to know it, to become aware of it, and to ensure that we implement it in the way we operate. If we look at the 12 categories of property practitioners which exist under the PPA, we still have estate agents, we have auctioneers, bond and bridging finance originators, HOAs who perform property practitioner activities, managing agents, property facilitators and intermediaries, and that would include your spotters or those who gather leads, business brokers, including sales of franchises and business undertakings, developers who market and sell their own developed property. That's important. So there are a certain number of developers who are required to register with us and be regulated. It's important to note that developers who simply purchase and build property, who are basically builders, and then once their property is built, use registered estate agents to sell or to rent out their property, are not required to register with us. Only those who perform property practitioner activities themselves are required to do so. We then also have timeshare and fractional ownership practitioners, property advertising platforms such as Property 24, you'll all be aware of them. And then payment processing agents. These are property practitioners who specialize in collecting and distributing trust money in terms of Regulation 2.4.1. So these are people like PayProp, you may be aware of them. They register as property practitioners, and their registration has certain specific requirements, which enables them to operate what we call a trust environment. And they can then deal with your trust account on your behalf. So they can open it, they can keep your trust account and they can deal with it instead of you having to do so yourself permanently. And then the last one is attorney employees. Attorney employees are those persons employed by an attorney's firm to perform property practitioner activities that arise within the attorney's firm. They don't operate as estate agents. They are not permitted to do so. They simply do property practitioner activities within the legal firm that arise within the legal practice. So this is where your property practitioner is marketing or advertising a property in a deceased estate on the instructions of the attorney, or an insolvent estate on the instructions of the attorney. And these are basically property practitioner activities, so it's necessary for them also to register with us and to receive not a fidelity fund certificate, but a registration certificate. So those are the important different industries or sectors that we regulate. And we'll move on now to some of the important changes in legislation. Some relate to timeshare and holiday letting, that's very important, and others relate to all other property practitioners. So those of you who operate in more than one space need to be aware of some of these aspects. First of all, anyone who operates in any property practitioner industry that is recognized by us must have a fidelity fund certificate. They must register with us, and they must hold a fidelity fund certificate in the industry in which they operate. Now, some property practitioners who are managing agents will have registered previously as estate agents, where you were required to do so under the old Act. The Estate Agent Affairs Act required estate agents who were also managing agents for a body corporate to also register. And you were registered as an estate agent, and you operated in the estate agent industry as a managing agent. That has changed, and your managing agent industry is now an industry on its own, and holding an estate agent FFC is not sufficient to be able to operate in the managing agent field. When a property practitioner operates in more than one industry, he must register in each industry and hold a fidelity fund certificate for each industry. Also, your business property practitioner or your firm under which any property practitioner operates must be registered by the person who is responsible for that firm. Your individual property practitioners, including your directors, members, sole proprietors, trustees, and partners, register in their personal capacity, as well as all employees and subcontractors or independent contractors who perform property practitioner activities for that firm and in the name of that firm. You will be aware that in the estate agent industry, we have principals who reach a certain level of qualifications, and they then are able to operate as principals in the estate agent industry. We do not have that currently in any of the other industries because the standards of training have not yet been developed by the Education Department. The standards of training are only available in the estate agent industry. So no standards of training currently apply to non-estate agent industries, and you can simply register with us as an employee or as a director of the firm which you register with us as a property practitioner. I've mentioned developers, so we won't stop there any further. We'll move on to the next slide, which is a brief discussion of the definition of a property practitioner. Not going to spend too much time on this. The definition is quite lengthy and quite involved, but it contains a few important aspects. that we need to be aware of. Please excuse me drinking. I have some sort of a throat problem, so I'm becoming quite hoarse. So apologies for that. All right, so a property practitioner means any natural or juristic person, right? In other words, a natural person or a company or a CC or a trust, which for the acquisition of gain, doesn't say necessarily for money, but for the acquisition of some sort of gain, operates on their own account or in partnership, and holds themselves out as somebody who performs property practitioner activities, and that they do so on the instruction or on behalf of a third party. So that's the basic definition of property practitioners. If they fit into those categories and that applies to them, and they perform the named property practitioner activities which we find in the definition, then they are property practitioners. The definition then goes on to include and to exclude certain practitioners who would normally be property practitioners evaluated against the definition, or who would not be evaluated against the definition, but are included by legislation. And we'll look at those in a moment. So in relation to your normal property practitioner, there's your criteria, and the activities which they perform, as you can see, are those who by auction or otherwise sell, purchase, manage, exhibit for sale, canvass sellers or buyers for, negotiate in connection with the sale of property or the letting of property, letting and hiring, exhibiting for letting and hire, collection of monies payable on behalf of a property, financing and bond brokers, anybody who in any other way facilitates the conclusion of a property agreement or acts as an intermediary in doing so. Those are the property practitioner activities which any property practitioner under Section A of the Act performs. Just an aside, the definition of property has an extended definition, and this is particularly for purposes of your managing agents. Your managing agents are those who manage property, and property means any immovable property and any interest, right, or duty associated with it, as contemplated in Section 2. Section 2 says the application of the Act. The Act applies to the marketing, promotion, managing, sale, letting, financing, and purchase of immovable property and to any rights, obligations, interests, duties, or powers associated with or relevant to such property. So property has an extended definition for purposes of managing agents. And the definition of manage in the regulations, which are promulgated under the Act, means a managing agent means any person who manages property, as referred to in subparagraph A1 of the definition of property practitioner in the Act, which we've already looked at, and any person who carries out any activity referred to in subparagraph C of the definition of property practitioner, and that simply refers to a person who manages property. And it includes an executive managing agent for purposes of the sectional title schemes management regulations. So that gives us quite a broad definition and a particular definition of what property practitioner managing agent refers to. We go back to the definition and we'll see that excluded are persons who do not perform these activities in the ordinary course of business, such as somebody who sells their own property or somebody who simply does a one-off referral to somebody and gets some sort of remuneration for it. Also, it excludes a person who is a natural person and they do, in the ordinary course of business, offer a property for sale which belongs to him or her in his personal capacity. So what we're talking about here is people who, for example, may have spent their life working as a medical doctor. They have perhaps accumulated some properties as investment properties during their career, and when they retire, they manage and sell or let these properties as needed, as their own personal properties and as their own little business to supplement their pension. So in that instance, as long as the property is registered in their own name and not in the name of a company or a CC or a trust, they do not have to have a Fidelity Fund certificate or register with us. Candidate attorneys and attorneys are exempted from being part of the Property Practitioners Act. They do not need to register as property practitioners, but there is a proviso, and subsection G says this applies to attorneys and candidate attorneys only when they perform a property practitioner activity in the name of their legal practice, from the premises of their legal practice, and such as arise within the course of their legal practice. So as soon as they start operating as a property practitioner or an estate agent or a managing agent for anything that arises outside their legal practice, they have to come and register with us, not as an attorney, but as a property practitioner, and obtain a Fidelity Fund certificate. Sheriffs are excluded as well. And then a further requirement or a further inclusion is a person who performs any function designated as a property practitioner function by the minister. So the minister can, by regulation, designate any person who performs a specific activity to be a property practitioner by virtue of the activity that they perform. And the minister has done this in Regulation 39. She has established that developers who would not ordinarily be part of the property practitioner definition are property practitioners if they sell their own property or market their own property, unless they do so through an estate agent, which means they don't then have to register with us. But if they market their own property and they manage their own property, then they must register with us as property practitioners. And then the definition goes on to include anyone who sells in any way any rights or shares in property, including timeshare and fractional ownership, any person who, for remuneration, manages a property on behalf of another, any trusts who perform these activities, any director, member, trustee, manager, or supervisor or employee of a property practitioner who performs any of these property practitioner activities. And you'll see a little later there are certain exemptions possible for specific types of directors. Attorney employees, as I've set out already, but not attorneys insofar as they operate within the legal practice that they have as a lawyer. So this is a new provision, the exemptions, which I mentioned. Section 4 permits exemptions to be granted for a maximum of 3 years to property practitioners, and it can be an exemption from any provision of the Act which you apply to be exempted from. It cannot be ordered retrospectively, and it should be noted that when you apply for an exemption, you have to use Form E1, which is set out in Regulation 4121. You must complete it and submit it with a motivation. The committee will consider it, and a certificate of exemption will be issued to you if you are successful. You have to mention exactly which section of the Act you wish to be exempted from, and you should also be aware that the exemption provisions include the criteria which we have to use in order to grant or refuse an exemption certificate. So we can't simply grant it for the asking. We have to see whether the application conforms with the criterion required for an exemption to be granted under Section 4, and we will then make a decision accordingly. An important provision under the regulations relates to trust accounts, and the fact that you can also apply now for an exemption from a Section 54(1) trust account, so that you don't have to hold a trust account only in certain circumstances. So in order to obtain an exemption from holding a trust account, you need to use the affidavit which is contained in Regulation 2. You need to submit it to the audit department, and you will then, in that affidavit, state that you do not receive trust money, that you have never received trust money, or if you have, you had a trust account at the time which has since been wound up and closed down, and that you no longer hold any trust accounts, that you will in the future not receive any trust money of any kind in your capacity as a property practitioner, and you will then receive a certificate indicating that you are exempted from holding a trust account. Please note that any estate agents who do rentals cannot be exempted from holding a trust account because they have to take trust money. Managing agents cannot be exempted from holding a trust account because they have to take trust money. And those under the managing agent banner who only perform property practitioner activities and receive trust money for body corporates can, if they wish, fall under a separate trust regime, which would allow them, if they themselves don't receive the trust money, but it is dealt with by the body corporate themselves through a sectional title managing agent, sectional title management Act account, which is registered as such. So it's registered as the sectional title management rules account, and they deal with the money and you don't deal with it. You would need to prove that by submitting a copy of their bank statement as well as a letter from the body corporate confirming that they deal with their own trust money in their own sectional title account in terms of the regulations, and that you do not do it for them. But any managing agent who receives any kind of trust money, any kind of levies, any money that comes into their possession, which they then use to pay service providers or to pay for services, means that they have to have a trust account. Right. For those who are new to the property practitioner regulatory space, it's important to note that property practitioners are required to follow a certain procedure when they wish to close their firm. Procedure existed under the Estate Agents Act in Section 32(7), and it exists under our Act in Section 54(9) to Section 54(14). And this is essential because property practitioners in all industries must be aware that you cannot, once you have a registered property practitioner business, simply resign or close the firm and without following the provisions of Section 54(9). Otherwise, you will find yourself liable for penalties for non-compliance, and Section 54(9) requires you to follow the closing down process because of the fact that you have a trust account, as well as the fact that you act for the public in the management roles that you fulfill. You should be aware that deregistration in one industry doesn't affect your status in a different industry, but non-compliance does. So if you are a property practitioner who operates in the estate agency field as well as in the managing agency field, and you fail to submit your audit report, or you become non-compliant in respect of one of your property businesses, that will prevent you from obtaining a Fidelity Fund certificate in any of your other industries as well. The next slide just deals with the section 54(9) to 14 process. It requires you to wind up and close the trust account, pay out trust money to the owners, deregister your firm with the PPRA so that you don't attract penalties, and annual audit requirements and fines. You should be aware that property practitioners cannot be issued with an FFC under a firm if they are a director of another non-compliant firm. So that's how your standing in one industry will affect your standing in another. Okay, employees may not be issued with an FFC if the firm and the director has not been issued with a valid FFC. So that's essential. And directors and principals should be aware that their status directly affects that of the employees. All natural persons pay FFC registration and renewal fees. Firms are required to pay an administration fee on registration. FFCs are issued for 3 years. Your candidates are issued for 1 year. We are hoping to commence the 1-year FFC within the next few months. Previously, we have issued them with 3-year FFCs instead of 1-year FFCs, simply because our system could not accommodate the 1-year requirement, but that is about to be resolved. Your regulated FFC template is now different to the old one. So it doesn't refer to your status or who your employer is, and it doesn't give your PPRA reference number. That makes things very difficult for everybody, but it's part of the regulations, and so at this stage we have to make use of it. Please note that under the new Act and regulations, you cannot renew your FFC simply by making a payment. So you have to now apply for an FFC renewal and submit a substantive application in order to do that. We will see that that is done on our portal. Alternatively, you can submit your application to us, and the new renewal period commences on the 1st of July. So please watch our website and our media platforms so that we can advise you exactly where you should send your application form and how your payment should be made. Your FFC fees escalate by CPI annually in terms of the legislation. And Section 50 is important. It's the old Section 27 with some changes, and it sets out what disqualifies a person from being issued with an FFC. Our FFC fees and all other services which we provide is to be found on our website. There is a substantive schedule of fees there for those who need to have a look and check on that. Okay, your registration process is quite simple. This is for non-estate agent practitioners. First thing you do is you register a firm. Your registration of a firm is done by your director, and it's submitted to manual registrations at the ppra.org.za. And the application for the firm is done by submitting your business property practitioner registration form. You'll find it on our website, signed by all your directors, and then you submit the required documents with that. And that is your firm documents, the documents, or whatever trust deed, or whatever type of practitioner it is, you will then use the documents which apply and submit your firm documents to us. A bank letter confirming that you have a trust account, and identifying it, and also confirming that it is an account held in terms of Section 54(1) of Act 22 of 2019. That is essential because the Act says that your trust account must be registered as a Section 54(1) Act 22 of 2019 trust account. And if it's not, you can be fined for that. So that's essential. Alternatively, if you have been exempted from your holding a trust account, then you will submit your trust exemption certificate. If you have a trust account, you will submit your auditor's letter of confirmation. You will also submit a company resolution which allows your director to apply to register the firm. You must submit a valid BEE certificate. That's not necessarily a compliance certificate, but it must have been issued. And that is only in respect of juristic entities. And then you will submit a SARS tax clearance certificate for all firms, whether it's a juristic entity or whether it's a sole proprietorship. And then you will also submit proof of payment of your statutory and administration fees. The directors then also register themselves individually, and they do this by submitting their form, their individual property practitioner application form, completed and signed, their ID document, the E1 form applying for an exemption from Regulation 33. I'm going to stop here for a moment. There's some very important information which you need to have in relation to this exemption application. Regulation 33 is the regulation which deals with education requirements. As we've said, no education requirements currently exist for any industry except estate agents. So you can be registered without any qualifications if you are not registering as an estate agent. However, there is a provision in Regulation 33 which says that no property practitioner can operate unless they have done a practical training course recognized by us and have passed a board exam or a professional designation exam. Now, obviously, because you can't have done that yet, you don't have such a thing. And on the basis of that, we require your Regulation 33E1 form. So what that is, it's simply a form which says I'm applying for an exemption. You fill it in and you say the exemption I'm applying for is Regulation 33. And the reason is because the required qualifications are not yet available for practitioners to pass. And if you submit it like that, along with your application form, you will then receive your exemption from that, and we will be able to register you and be able to issue you with your Fidelity Fund certificate. Okay, your employees or your independent contractors, and that's all levels, must then register individually using the same form, using the E1 regulation exemption, Regulation 33 exemption. You will need to submit a letter of employment signed by the director and the employee and stating the reference number of the director and the firm. You will also then need to submit proof of payment of your registration fees, and that also goes to manual registrations at the ppra.org.za. Very important for all property practitioners to know who have not previously been regulated by the PPRA or the EAAB. Auditing is an essential requirement for property practitioners in respect of their business as well as their trust account. Please, first of all, see your audit, the audit compliance manual, which Audit has put out. It's on our website, and it gives you a lot of assistance on what is required to be audit compliant. You will also see that from time to time we publish practice notes and directives to assist you to understand where there's any changes or where there's any problems that you may encounter, and we may advise you then how to deal with them. Okay, all firms who have a trust account must submit their annual trust audit report in the format prescribed by the PPRA within 6 months of their financial year end, and this must be submitted to the PPRA in good time, or penalties will accrue monthly. Also, all firms, in terms of the Act, must have their business accounts audited within the same period, but you are not required to submit them to us. You simply keep them, and if our inspectors arrive and wish to inspect them, you will be able to provide them. There is an important exemption here, and this is Section 23 of the Act, which provides that firms who don't have a trust account and who have a turnover of less than 2.5 million per annum do not need an auditor, and they can have their business financials reviewed annually by an independent accountant instead of an auditor. So that's a lot cheaper. So you don't have a trust account, so obviously you don't submit a trust account audit, but you do have to have your financials prepared and reviewed for your business, and those you can then have done by an independent auditor, and it doesn't need to be audited. And that's only if you don't have a trust account and your turnover is less than 2.5 million per annum. Otherwise, if you do have a trust account, then your trust account and your business accounts must be audited by your auditor, and your trust account audit must be submitted to us within 6 months of your financial year end. Okay, so that's the auditing provisions. And then a couple of general discussion points. Inspections and compliance. We have inspectors who are appointed to issue compliance notices for minor misconduct and to impose fines. If there is serious misconduct, which cannot be dealt with by way of compliance notices, the Act requires that we then issue a summons and institute disciplinary hearings against the agent for a sanction to be imposed by the disciplinary tribunal. We also do mediation of industry disputes and consumer complaints. We also do mediation in relation to commissions, and where there's any kind of disagreement which you would like us to mediate on. I've mentioned the education requirements. If you are an estate agent, you must comply with the education requirements in regulation, the 2008 regulation on standards of training for estate agents, and all 11 other industries are registered without qualifications at present, and the E1 form for Regulation 33 exemption is required, as I've said. Please remember that there are certain provisions in the Act where if you don't comply with them, the Act makes them a criminal offence. So these, sections 47, 48, which is operating without a fidelity fund certificate, section 50 and 56, which is various non-compliance, and some of the regulations do attract criminal offence status. So if you are guilty of any of those, you can be charged criminally by the state. Fidelity fund certificate renewal is required by the 31st of October of the last year of validity of the fidelity fund certificate, and late renewal attracts penalties. Very important, where you have commission payments for the sale or rental of any property, section 56(5) prohibits any commission payment if you have not provided the conveyancer with your fidelity fund certificate, as well as that of your principal and your firm. And in relation to managing agents, the Act provides that if you do not have a fidelity fund certificate, you are not entitled to charge for any work that you do which constitutes a property practitioner activity. And that if you are paid anything, that money has to be repaid on demand, and non-compliance with that constitutes a criminal offence. Disqualifications. Section 50, as I've mentioned, disqualifies anybody from obtaining a Fidelity Fund certificate who has not submitted a BEE certificate, if they're a juristic person, if they haven't submitted a tax clearance certificate, if they are any firm at all, if they've been guilty of any form of discrimination, if they are not compliant with any education requirements, if we have paid a claim which arose because of the misconduct of the property practitioner out of the Fidelity Fund, and foreigners who do not have the required documentation allowing them to remain in South Africa and work in South Africa are also not permitted to hold Fidelity Fund certificates. We also have an important transformation mandate, and in the Act it now creates your research centre, your transformation fund. The Act also has a number of anti-discrimination provisions in the Code of Conduct and in Section 50 in order to ensure that we properly transform the industry. Something else that's important is printed information and business documentation. There are now requirements under the Act as well as the regulations which provide that all business material, correspondence, marketing material must reflect the business property practitioner for which the practitioner operates. That is, its name, details, contact details, the type of entity that it is. In other words, if it's a company, if it's a CC, if it's a trust, or if it's a sole proprietorship, or if it's a partnership. It must also confirm that the entity holds a valid FFC. I've said the FFC number must be put in there. In fact, that's not correct. You don't have to include your number. It's simply that you have to state that you have a valid FFC and you guarantee its validity. And you should be aware that your FFC should be displayed prominently in your place of business. Thank you very much, ladies and gentlemen. I hope that has been helpful in understanding and navigating some of the new provisions. And yes, I'm happy to take any questions. Naledi will deal with that. Thank you.
Okay, thank you so much for the presentation, Advocate Val. I'll go to the chats, I'll go to the Q&A space. Then I will also unmute so that we get the questions. I have a question from Dan. As education standards and training has not been developed, how are you going to deal with the registration of a principal under the new managing agent industry? Who will then be a principal at this stage?
Okay, thank you. I think I dealt with that in the slides, but just to reiterate, principal is a status which is attracted by estate agent industry only. There are no principals in any other industry in the property practitioner space except your estate agent, because they have complied with the required estate agent standards of training to allow them to qualify as a principal. Because there are no education standards at this stage for any other industry, nobody in any other industry has the status of principal. So we do not register you as a principal. We register you either as the director of the firm or the business property practitioner that you operate under, or as an employee of that firm. So at this stage, there is nobody who is a principal because you have not attained that standard. And we don't know yet in the future whether the education department is going to have standards of training which will allow you to be a principal in that industry. We don't know what they're going to call it. They might call it something else. They might have a different type of education qualification regime. That's not known yet. So at this stage, all that happens is you register, as I said, in the slide. If you look at the slide on how you register, you will see your business owner or business practitioner registers as the director of that business, and everybody else is registered as an employee.
Okay, thank you so much. I have Lee. Please confirm if you are an estate manager for homeowners association or body corporate, must that manager be registered?
It depends what an estate manager does. Okay, it's something that we have been at pains to tell everybody. It's of no value to come to us and say this is one of the names that we give one of our staff. Must they register? We have no way of knowing because we don't know what that person does. So the criteria is whether that person performs a property practitioner activity. So if they do anything in relation to selling or renting or negotiating or managing in relation to the funds, the rights, or the duties of the body corporate or the HOA or whatever the community scheme might be, then they must register as a property practitioner. Usually the people who deal only with the accounting, your accountants, they don't usually have to unless they deal with trust money. If they pay out trust money and they have control over trust money, then they must be registered. If they see clients and they assist clients with the property rights and duties, the management and maintenance of their property, then they must be registered. But people who simply do the actual maintenance work of a complex, they do not need to register. So it depends entirely on what they're actually doing, what the function is.
Okay, thank you so much for that, Advocate. Deboho says, does business rescue practitioners and liquidators need to register?
No, they don't.
Okay, thank you so much for that. Let's go to the hands. I'll go to the chat again. I'll come back for that. Luann, please unmute and ask your question.
Can you hear me?
Yes.
Yes.
Hello. Thank you so much for the presentation. I really appreciate it. It's very insightful. I've got a few questions, if I may, if you could just bear with me, if I could just ask them. The first one is on the current NQF5, there is a property management elective that you can do as part of the NQF5, and I have actually undertaken that. So how will that serve my business as a managing agent in terms of the education, because that already states as a property management elective? That's the first one.
Sorry, I'm not understanding. How do you mean, how does it affect you as a managing agent?
So you're still defining the education for managing agents, but there isn't a property management elective as part of the NQF5.
NQF5, you're talking about the NQF5 for estate agents?
That's correct. It's got a property management elective on it.
Yes, that's only because estate agents do a certain amount of management when it comes to rental properties. So it relates to the work that they do as estate agents. It's got nothing to do with your status as a managing agent. That is not a requirement for a managing agent at this stage.
Okay, excellent. Thank you. And then the other one is the applications. If you're currently a managing agent and you want to register as a facilitator and intermediate, the current applications only state if you've got a new business or if you bought a business. So how do you register an existing business with both registrations?
You mean if you've got one registered under one firm and you want to register under one industry and you want to register the same firm under another industry?
That's correct, yes.
Yeah, well, that's no problem. That the application form makes provision for that.
You okay, it says new business.
Sorry?
It says new business or purchased a business. So would you just put their new business / existing business?
Yes.
Okay.
Yeah. It's a new business. It's a new business in that industry.
Yes. Okay. Okay, thank you. And then the next one, sorry, I've got a few. Hopefully I'll go through them quickly and it'll help with some of the other questions. So in terms of the estate agent's function with residential property management, I understand that obviously a FFC property practitioner can write leases, do leases and sales, but can you manage residential property as a managing agent firm where you are not writing leases or doing sales, but you're managing residential properties?
Okay, a managing agent is somebody who manages property in a community scheme. Okay, so if you are managing property in a community scheme, then you are a managing agent and you must register as such. Estate agents, part of an estate agent's duty is rentals and managing a rental contract. Okay, so they collect the money, etc. That's part of their job as an estate agent. Okay,
yes.
But it's not a community scheme management in the same way that managing agents do.
So what if you're managing the property, but you're not collecting rentals or managing the lease? You're just managing the property repairs and inspections and things like that. Is that considered managing agent still?
So you are not operating as an estate agent for that client.
No, so it's residential property, but there's no lease agreement or managing monies or lease terms. It's purely doing inspections and going to the property to see the state of the property and giving guidance on maintenance and projects, basically.
Okay, well, it depends to what extent you're doing some of those things, but in most instances, simply guidance on investments and guidance on maintenance is not in itself a managing agent criteria, unless it's in a community scheme. So, managing agent does something very different. So that would usually be within the estate agent realm, unless it's an investment type function, in which case it's not a property practitioner activity at all.
Okay, all right, that answers that. Thank you. I think it's not a property activity then. I wanted to ask the time frames for all of these registrations for these different silos. What time frames are we looking for these?
Well, everybody should have in fact registered already, and we started registering last year on the 1st of June. We started registering all industries, so everybody should already have registered.
Okay, but is there a cutoff that we're going to be working to? Do you know?
No, there isn't. We simply do it immediately, if not sooner.
Okay, and then in terms of referral fees, so if, for example, you are a managing agent or a facilitator and you are referring a client to, say, a property real estate person, do you have to be licensed as an FFC to refer to a sale or a lease, or can you as a managing agent become a referral, or a facilitator be a referral to?
You have to then register as a facilitator or intermediary in that space, in that industry.
Okay,
unless it's a once-off. If it's something that just happens once-off, then you don't need to, because that's not your business. You're not actually operating in that business. But if you're doing it, on multiple occasions, and it's becoming your business, or you're doing it in the ordinary course of what you're doing, then you have to register in that space as an intermediary.
Okay, amazing. And then in terms of the trust account audits, if you're a business and you've got a trust account and you've got to audit the trust account, I understand that, but you're earning under 2.5 million, the current account, my understanding from previous sessions is that then needs to be independently, or have an independent financial review, not an audit, if it's under 2.5 million, as long as the trust account is audited and submitted. Is that correct?
No, you cannot. You cannot. If you have a trust account, then your business must be audited. Doesn't matter what your turnover is.
Okay, I understand. So it's both must be audited then.
Yes.
Okay. Yes. And then I think the last question I had was, I've got two more. The managing agent, are all financial activities for every scheme passing in and out of the trust account, not the current account?
Sorry, I'm not with you. Please repeat.
So the managing agent schemes with the trust accounts that they're opening. I know obviously if
Yes,
you've got the reserve fund, that will be in a separate trust account, but the collection of levies and payments of levies, is that going, all of those functions going through the trust account and not the current accounts anymore?
absolutely. Any money that you deal with that's not your money goes into a trust account.
Super, thank you. And then the last one that I had was, if you've got a shareholder that is a silent partner in the business, they're basically not actively operating in the business, do they still need to be registered as a as a practitioner?
Okay, technically they do, but there is an exemption for them in the regulations, Regulation 4123, which provides that if you are a director who is either a non-executive director or an HR director or a financial director or gives you one other kind of director, I can't, an IT director, or any kind of director who doesn't deal with the day-to-day property practitioner activities of the business and doesn't manage property practitioners on a day-to-day basis, can be exempted from holding a Fidelity Fund certificate on the basis that they are that special kind of director and they don't need to hold an FFC. So that you do by submitting an E1 form. You would submit that along with a resolution from the directors to say we confirm that this director does not do the following work, and we ask that he be exempted from holding an FFC, and that plus your company documents to show that the person is a director, and if in case it's specified what director on the company documents, that would be helpful, although it's not necessary. And you would submit that to the exemption application, the exemptions department, and that is at section 4, exemptions at the ppra.org.za. Okay, so please note section and then the number 4, exemptions at the ppra.org.za. Please don't send it to exemptions at the PPRA, because that is estate agent equivalency exemptions, which is completely different.
Okay, excellent. And what about a shareholder that's not a director but has shareholding?
He doesn't have to have it.
He doesn't have to have it, so he doesn't need an exemption.
No.
Amazing. Thank you very much, ma'am. I really appreciate that.
Thank you. Let's quickly go to Serena. Please unmute and ask your question.
Hi, Deborah.
Hi.
So in terms of the industry, what managing agents have always been registered as estate agents, because there was nothing else. We were always estate agents, but only practicing managing agents. So now we're still only practicing managing agents, but the industry is not quite sure, because whether you have a trust account or you don't have a trust account, we don't know how to deregister as an estate agent without providing the documentation that you require in terms of your legislation, saying the trust account's closed, the business is closed. We're still carrying on as we always have. And I'm still not getting any resolution from the PPRA as to what the managing agent actually needs to do and can do in terms of their business, because we're going to carry on our business, what you need to deregister us as an estate agent.
There is information on our website, which was quite comprehensive on what has to be done. So have a look at that. But to explain it to you, first of all, under the old Act, property practitioners, or rather estate agents, included managing agents who operated for bodies corporate. I don't know what you mean by practicing and not practicing, because that was not a criteria. The criteria was whether you operated for a body corporate or for a share block scheme. And if you operated for a body corporate or a share block scheme under the old EAA Act, you had to register as an estate agent because you were included as an estate agent.
Yes.
Now, any form of managing agent who performs any of the activities of estate agents or managing agents within the managing agent definition are required to register as managing agents. If you are still operating as an estate agent, you remain in your estate agent sphere as well, and you register separately as a managing agent. If, however, you are no longer operating or you never operated as an estate agent and you want to deregister yourself, what you need to do is you need to submit a request to registrations at the ppra.org.za, and you will ask for the deregistration of your firm. What you will need to do is you will need to say that specify the firm, ask for it to be deregistered as an estate agent, and along with that, you will submit your application to register as a property practitioner. Now, as far as your estate agent trust account is concerned, that has to be up to date with an audit report up to the date when that estate agency is stopping its operations. Okay. Are you opening a new trust account, or are you using the same trust account?
No, there's two different scenarios. So I'm asking for members of NAMA, those that have and those that don't have. But either way, they've got their managing agent certificate with the PPRA, but they are not doing anything as an estate agent as what the PPRA now deems an estate agent to be doing. That's letting, selling, etc. They're not doing that. So they never have done that. But my understanding is we've got to deregister
have you registered as a managing agent?
Yes, yes.
Okay, so you've got a managing agent FSC?
Yes.
So what I need to know as to what you do with your estate agent status is whether you are still using the same trust account that the estate agency used, or whether you have opened a separate trust account when you registered as a managing agent.
No, same trust account, nothing's changed.
Okay, so that means you need to then advise them that you are now operating as a managing agent. You need to submit to us a request to deregister the firm as an estate agent, and you need to ensure that you have submitted a winding up trust account audit up to the date when the estate agency stopped operating.
There won't be a winding up because remember the trust account is still going to be open. There's no change. So there won't be a winding up of the trust account.
No, there will be a winding up of the trust account. You are not closing your trust account. You are winding up the activities of your estate agency, okay, in the same trust account. So in other words, that's why I specifically said up to the date when you cease operating as an estate agent. So your auditor will then do, from your last audit as an estate agent, he will do a winding up report up to the date when the estate agency closed and the trust account is now only operated by the managing agent.
So that would be when the legislation changed on your part to instruct us. So was that in 2023?
No, it will be up to the date when you registered as a managing agent.
Okay.
I think I got it. Is that fine?
And if there's no trust account involved?
Well, there has to be a trust account. You can't operate as a managing agent without a trust account.
As a managing agent, yes, you can.
No, you can't, because you're going to be dealing with trust money.
No, but some managing agents they manage body corporates where the body corporates are in charge of their own funds.
Then you have to do an exemption under section 4123 of the regulations, as I explained in the slide, where you have to then go to the audit department and say, right, I want to be exempted from holding a trust account because my body corporate has its own accounts, which is held under the sectional title Management Schemes Act. And here is the proof of it. So please exempt me from holding a trust account. Otherwise, you cannot operate without a trust account. That is operating illegally.
Thank you.
Sorry, can I pose the last question quickly, because I don't get any response from the emails.
We're going to come, hello ma'am, we're going to come through because there's people who raise their hands. We want to recognize them. There's questions on the chat box and also on the Q&A. We want to give everyone a chance. Colleagues, can I ask that we be quick so that we allow everyone to ask? We're going to come to you. We see you. Sipe, please unmute quickly and ask your question.
Thank you very much. I want to check. I just saw someone in the chat box. It indicated that they've been trying to apply or register without any assistance. And one of them I've been trying for the past 3 years. But now, be that as it may, my question is that for people who unfortunately found themselves operating or doing this work that is done by property practitioners in remote areas and
Sorry, I
haven't
can't
been
hear
getting
you.
the
Please
assistance.
speak louder.
Okay.
Hi, please try again.
Yeah, I'm asking if I'm audible now.
Yes, now you're clear.
Yeah, I'm saying that I saw a question in the chat that was saying that the person has been trying to register to no avail. And I'm one of those people who has been trying to register for the past 3 years and I couldn't. But now where I'm going is that as an entity that has been operating in a remote area or in a remote province and couldn't register officially, how can we get exempted for such? Because unfortunately, we did have to find ourselves doing some property practitioner functions or responsibilities. And in terms of our education and trying by all means to stick to the best practice, we have done that and we've kept accurate records of the work that we have done. But now what's lacking is the credibility as far as getting registered and obtaining a fidelity fund certificate. How can we go about or buy with that? I hope I'm speaking for a couple of other people who have been facing the same challenge as well.
Sorry, I don't understand. Why could you not register? Can't operate.
There was never a response to emails.
Well, then you can't operate. You can't operate if you don't register. So there's all sorts of options that you have in relation to approaching us. If you need to register, you can come into the office. You can speak to email Naledi. She will get someone to assist you. I will get someone to assist you. There's plenty of ways of doing it.
Okay, thank you very much. I've written to the manual registrations email. I'm hoping that we might get some few things moving on. Thank you. Thank you.
Yeah, you can CC me on the stakeholder email. I'll also drop my email on the chat, and let's get a registrations officer to help you and see what could have been the problem. Sometimes it could be that documents are not compliant. You know, they would write back to you to say there's few things that are missing. And we've seen most of the times property practitioners don't reply back or they take time, hence the delay. But please email you so that we can assist. Dennis, I'm going to go back to the chat after Dennis, then I'll come back to Moketwa. Dennis, please unmute.
Thank you very much. I'm still coming from the chat. I'm going to have to discount the argument a bit here. I've also been 2021 trying to register. I even launched exemption applications at that stage against the whole registration. Also, with due respect, if you refer to the regulations, if you, as the PPRA, not process it within 60 days, it's automatically deemed exempted. So, sitting as a firm, I've actually been exempted since 2021. Even now on your website, if we go to the website, on the notices, it says general notice of confirmation that the system is effectively non-functional, etc., etc. This is 4 years worth of strife and back and forth. I've got the president of NAMA involved with my registration. I've personally been to your offices multiple times. I've spoken to role players. Let me rather, okay, without becoming antagonistic, because it's really getting to a point where the frustration is beyond, and we know we're constantly playing with different role players. I understand you've been placed in a role, but we had someone before you and someone before that. The question is, when is people are going to pull a hard deadline and tell us that they're going to effectively start penalizing us for non-registration? Because in as much as I want to say, yeah, it's within your powers, the most of the lack of registration, etc., lies fully in your ball pit. PPRA has been a non-functioning body for 3 years, and you've only gotten your act together in the last year and a half, truly speaking. And that's out of, and I can promise you 90% of the people here will concur with me. When are you going to start hitting us with penalties? When is the hard deadline? And also specifically relating to the 10 other new fields of registration, developers, etc. When are you going to draw the line in the sand? And when are you going to start hitting us with things so that we know we can operate? Because it's great and well we're being told now, there's everything in place. But realistically, for years and years and years, we've been talking to an empty vessel. And I know it's not this, I'm not directing it to you, your predecessors, but realistically, it's been 4 years. I've launched exemptions. I've lost multiple sets of registrations, and it just goes into an empty void. I've been to your offices personally. I've been to NAMA. I've been to this. So just please clarify for me, when are you going to draw the line in the sand, and when do we know that we're going to be starting to get into trouble? Because it's with due respect, just telling us now there is systems of things. The reality is it's on your websites. It's on your top advertisement. Your systems are down and non-functional. So it just feels like we're swimming upstream, trying to adhere to your whatever the government thinks of next. Sorry for the frustration, but it's really been years now.
Okay, first of all, please note that you are incorrect with your information that you have been exempted because it's been more than 60 days since you applied.
I'm referring to the regulation, ma'am.
Yes, regulation. I know exactly what the regulation says. So please go and have a read, and you'll see what the regulation says.
If the authority fails to comply with regulation 41.4 foregoing, the application is deemed to have been approved by the authority.
Yes, exactly. So where does it say you've been exempted? It says you've been deemed to have been approved. It doesn't talk about exemption.
But that 41.4 relates to exemption applications, ma'am.
No, it doesn't.
Well, I'm sure it does. I've got the document open in front of me.
I suggest you just get hold of Naledi, and we'll arrange a time when you can come in and see us, and we can assist you with whatever is not compliant.
And then in terms of your systems being down, is that being fixed? I'm referring to the notice now, the 2nd of June.
Yes, and you will see what the notice is. It doesn't say the systems are down. It says that there are some of our aspects, some of the things that we are doing in our processing, which we are unable to do at the moment, not everything. And as a result, there will be a delay, and we extended the period by 20 days.
What period is that, ma'am? This application extended for 49.1. What is that extension?
The 30-day requirement, which is extended by 20 days.
The 30-day requirement for what, if I may? Sorry? Relating to registration?
Relating to the issuing of an FFC, yes.
The 30 days, for you to issue us 30 days.
That's a compliant application. So remember that both the 30 days as well as the 60 days applies only if your application is compliant.
Compliant, okay. And if we sent off things in March and we, as I say, we got NAMA's president involved, it's still just dead ends.
It's fine. I dropped my email on the chat box. Please email me then so we can arrange a meeting for you. They will go through your application and check. And I think they will be able to give you answers on why there was a delay. They need to open the system with the reference number and look at your profile.
No, ma'am, it's just my 4th set of registrations for my company now. 4 times I've attempted it, and it's just, anyway.
Yes, that's what I'm saying. I need to link you.
Same excuses every year. I've sat in these webinars for 3 years straight. We're just going in circles. But anyway, thank you very much.
Remember, colleagues, the webinars, it's not really only for registration. We're just imparting information for understanding, to give you clarity on some of the questions that we would have. We always have registrations officers available at the front desk. They're willing to sit with you, bring all your applications, or you can request a virtual meeting. Vukani, the registrations manager, is always doing virtual meetings with practitioners.
Again, I've done that
to go through.
In person, it's gotten me 0 results. Twice I've driven down to.
And what are they saying when you
sit there, you get the list of documents, you get personal details, you send the same things for them. 3 months later, we are sitting and nothing.
No, but if the documents are correct, they will issue the FFC.
They didn't even communicate with us, ma'am. They just leave us in the lurch. It's just blank.
I'm not defending them, but I know that if documents are correct, there's no way they can keep your FFC. They will issue it. There must be something. Let's look at the documents. You find that maybe there was something that was missing from your documents. It must be also communicated clearly by our registrations officer. They must communicate clearly what is it that they need from you so that you understand as well.
Receipt, beyond that, nothing.
Can you look at the chart?
Then they promise response. Then they still kept quiet. Then I followed up with Nama, president, and what's not. It's just do you have the necessary resources to actually work through this? Because we're talking of hundreds of thousands of property practitioners. That's my concern.
Yes, the advocates department, they are issuing FFCs now as we speak. They are issuing FFCs. Please look at the chat. Look at that email that I've put on the chat. Can you send me an email? I'll stand up after the webinar and go to the department and see who was helping you and ask the person why are they delaying in, assisting you and giving you an answer. But maybe because I'm looking at the time, there's a lot of people who have questions.
100%.
Let's give others.
I don't want to hold it up. Please go ahead. Thank you very much.
Let's give others, yeah. Advocate Vile, I have Wendy. Wendy on the chat says, can I get a FFC certificate as a managing agent if the company is not registered?
No, you can't. Nobody can get one unless your company is registered. Your company has to be registered by law. So they have to be registered with us, and then you can get an FFC once they've got an FFC.
Okay, thank you. Mukhetwa, please unmute and ask your question.
Thank you and good morning. Advocate, I just wanted to clarify on the issue of the board exam for estate agents. I had an FFC in 2018 and then I stopped in the business for a while, but I've cleared everything with the PPRA in terms of deregistering the company and everything. Now I want to register, I'm in a process of registering my new company. The FFC that I had was a principal agent status. So I just wanted to understand, because I have a confusion on this, the PPR, on the principal agency status and the qualifications. I'm a conveyancer and I have the commercial property practitioner certificate. So will I, when I register the new company, retain the status of the principal agent, or will I still be required to write the board exam despite the history that I have?
Do you want to register as an estate agent or a managing agent?
As an estate agent. The managing agent, I don't have the business as yet. I'll register at that time, but I want to start with the estate agent first.
The state agency, you have to have your principal. If you have the qualifications to be a principal, as you were before, and all the education requirements have been complied with, they will register you. If they haven't, you will have to pass your qualifications in order to get it, or you will have to get an equivalency exemption.
Okay. I think now you answered me, because I wanted to ask you if I'm a conveyancer, because it's a property a lawyer. So the equivalency exemption then will then lead me to that registration and retaining my principal agency FFC.
I don't know. It depends on what the education department exempts you from.
Okay.
They will look at your. They will look at your qualifications. They will look at what education requirements you have done, and they will say, okay, we will exempt you from the NQF 5 or this whatever, and they will tell you what you still have to write.
Then that's fine. Now I do understand. The last question, in terms of the categories of the property practitioners, if I want to say register 1, 2, 5, 8, do I do separate applications, or do I just tick on the form? Because I saw the form has got all those categories, or should I do each batch for each category?
You have to have a separate application for each category.
Okay, thank you so much. Thank you, appreciate it.
Okay, thank you. Let's go to the next hand. Please unmute Ansi and ask your question quickly.
Good day. Thank you for taking the question. I think I just want to share the same frustration to the fact that one do not get responses on your emails, and even if you phone in, they offline, or they cut you off and you can phone back 3-4 times trying to resolve an inquiry. But I have just sent an email to you now, Naledi, with my inquiry, and I hope that you'll be able to respond back on that, then on the email itself, as to who and why and where I can't move forward. Thank you so much.
Okay, no apologies about that. I'll look at the email after the webinar. Let's go to V. Please unmute. V, please unmute. Okay, they seem to be struggling. Marcus, please unmute.
Here we go. You can hear me?
Yes.
Thank you for taking my question. It's very simple. If we want to get BE exemption, how does one go about that?
You go to registered BEE analyst. Most of their auditors are, some of them are just accredited, anyone who is accredited by the BE regulator, and they will provide you fill in their forms and they will provide you with a certificate. Or if you don't qualify, in other words, if the BE doesn't apply to you because of the fact that you are maybe a sole practitioner, then you can complete the affidavit, which is in the legislation, and then you submit it to us.
Oh, so the affidavit is valid, because I'm familiar with that, and that's what we have used previously. So that is a valid means. Okay, great.
Yes,
thank you. Thank you.
Okay, thank you for that. We have Johnny in the Q&A. If you are registered as attorney employee, are you not allowed to handle rentals, etc.?
No, you can't handle rentals at all, unless it is rentals that arise within the legal practice. So in other words, let's say, for example, the attorney is dealing with an insolvent estate, or has been appointed as a curator or a liquidator, and there are properties that are related to that are being rented out, and you have to deal with that. Those you can deal with, but you can't go out there and deal with rentals from the public and just, and place people or sign leases or whatever with members of the public and provide them with those kind of services. Then you've got to be a property practitioner.
Okay, thank you, Advocate. I have another one from Yolanda. Morning. If a principal property practitioner has a firm number and registered with the PPRA, and a sole prop was working under another firm, I think she's saying she has a sole prop working under another firm and wants to break away and go on her own. She has a firm number. Okay, I don't understand this question, Advocate. She has a firm number. What does the PPRA require from us in terms of payment and paperwork? Yolanda, maybe you can raise your hand and clarify the question. I don't know if you managed to understand it, Advocate.
No, I don't. I don't know. I don't understand.
Okay, let's go to Mariska. I've applied for an estate agent FFC and submitted all documents and proof of payment, but haven't received any feedback. Who can I email? Okay, Mariska, please look at the email on the chat. I'll follow up for you and see who's dealing with your application in the registration units. And I think I'm going to skip all the questions regarding the FFC's follow up on this. Let me see if we have a question related to managing agent. Heloise, what is the amount payable when you register a firm with the PPRA? Advocate, if you know it by head.
Just have a look in at the fee schedule. There are a number of different scenarios, so you have to look and see which one applies to you. It's on our website.
Okay, thank you. Mariska, hi. If a company changes the status from CC to PTY, do I need to complete a deregistration form for the CC? Please advise.
Okay, we will in fact deregister the CC, but it's not in fact a complete deregistration. We will simply change it to a company. But what you need to do is you need to send us in all your company documents and apply for the change. So you'll send us an application form where you want to register a company with all the required documents, including your company documents, and just put in a covering letter advising us that you have a current one and you will be using the same trust account. So if they can just transfer the trust account over to the new entity. You will also need, of course, a letter from your auditor confirming that he is now the auditor of the company. You will also need your trust account letter from the bank to confirm that the trust account is now held by the company and not by the CC. And all those documents will need to be submitted, your BEE certificate, etc. And with a covering letter simply saying, please, can you deregister or cancel my previous FCC and replace it with the company.
Okay, thank you. Let me go back to the hands. Let's see who has, Mketwa, you back again. Is it a follow-up question to what you asked before? Please come through.
No, sorry, I was dropping my hand. Sorry.
Okay, Kudzi, please unmute.
Okay, thank you. Good day. I just want to get clarity. Is there a difference between a managing agent and an estate agent who handles rentals? That's my first question. And the follow-up question to that is, if I'm an estate agent who is handling rentals, for example, and then I want to register as a managing agent, what exactly is the difference between those two?
Okay, your rental agent can manage a contract in relation to the rental that he does. Managing agent is someone who deals with community schemes, manages property and community scheme development, and it's not related to a rental agreement or any kind of estate agent activity. It's simply related to the management of the community scheme. You can be registered as both, and once you have to manage properties in relation to community schemes, you would then do the application in the normal course and apply for an FFC as a managing agent as well.
Okay, thank you very much. And maybe one last follow-up question. You did mention that if, say, for an example, a firm is not compliant in one particular field, then it can affect their FFC in another field. Did I get that correct?
Yes, in one industry, if you have a firm in one industry and your firm is not compliant and you cannot get an FSC because you are not compliant, then you will not be able to get one in any other industry either.
Okay, thank you.
Okay, thank you for that. Let's see. We have Luen, please unmute.
Thank you. I've just got a follow-up question, if I may, please. Just in terms of the interns and the candidates, I see the new FFC is going to be issued for 1 year. Does that mean that when a candidate now has gone through the internship and gets the FFC, that they've got 1 year to complete NQF4, whereas previously they had the 3 years on the 3-year certificate? If you could just
That's right. They only have 1 year because the Act says, the regulations say that they can't be a candidate for more than a year. In fact, it says they can't be a candidate for more than 6 months. And we as a board have extended that by a further 6 months based on the regulation that allows us to do that. So candidates can only be candidates for 1 year.
Okay, super. And then the other question I had, I did pop it in the chat, but you mentioned that business accounts registration or accounts business registrations have got an admin fee, and I've looked on the fees online. It doesn't say business registration admin fee on there. Do you know what that cost is?
I think it would say firm registration. It's $640 as far as I know.
Registration. Okay. Yeah, it didn't say it. So that's why I asked. So that's fine. I'll have a look for that 640. And the last one I wanted to ask you was about the hosting activities, on Airbnb. Are those considered property practitioner activities if you are doing the hosting in terms of allowing people access to the property, getting them checked in, getting them checked out, that kind of thing, doing property inspections?
Okay, well, I'm not quite sure what hosting entails, but as far as the Airbnb is required to register with us. If you're doing it yourself, just for your own property, then obviously you don't. But as far as doing hosting is concerned, I'm not. It would depend exactly what it entails. What the money arrangement is, how it works, and exactly what you do and who you act for, what mandate you have. So
Okay, it is a an Airbnb hosting activity,
yeah,
and
that doesn't tell me
basically,
anything. I need you to tell me exactly what do you do for it, and who is
yeah.
your contract with?
So the contract is then with it basically is with the owner of the property, and they
Right.
pay the host to screen people, answer people in terms of their inquiries on the
Okay.
property,
Yes.
access the property, and let people in, and then clean the properties and that kind of thing.
Yes. So that will definitely be a property practitioner activity.
Okay, super. Thank you so much. I really appreciate that.
Thank you. On the chat, advocate, there's Albert, but I know you answered this. I'm not sure. Maybe it's being asked if you joined late. Good day. Do managing agents fall under estate agents or non-estate agents? But you did cover that. If you want to remind everyone who joined late.
Okay, sure. Under the old Act, estate agents were the only ones that had to register with us. And included in the definition of estate agents was those who had managing agent mandates from community schemes who were body corporates or share block schemes. Now, under the new Act, you have to have a registration as a managing agent if you manage any community scheme property, and you can no longer be registered just as an estate agent. You have to be registered as a managing agent in the separate managing agent industry, and you follow the application as I explained. If you want to continue operating as an estate agent, in that you are going to do estate agent activities as well, then you can leave your estate agency open and registered with us. Alternatively, if you don't want to perform estate agent activities and you'll only be performing managing agent activities, then you can deregister your estate agency and register your managing agency in the correct industry.
No, thank you so much. We have a last hand coming from Oba. Please unmute.
Good. Thank you. Yes, my quick question, I just wanted to get clarity so that I understand very well. So, according to my understanding, I just want to check. Let's say if I'm a managing agent, and I know last time there was a webinar where we say if you have got a staff or a team members who are handling the the payments of the clients, it says they must also have an FFC in order to comply. So my question is that let's say if by may say I have someone who only understands the accounting of transacting there and there without having a proper experience in this managing agent. So does that mean also that person can register his or her own managing agent company without that experience? Because for me, I don't know if I'm mistaken. I stand to be corrected. Because in a way, the way in which are we saying to be a managing agent, you don't need experience, you don't need qualification. As long as you have got FFC, you are registered, it's fine. You are able to run that. So I just want to be clarified on that. In case if I've missed something, then I will appreciate. Thank you very much.
I'm not 100% sure of the question, but what it sounds to me you're asking is what the qualifications are for a managing agent. And as I've explained, at the moment, the Education Department is busy developing the required experience and knowledge qualifications for managing agencies. At the moment, they haven't done it yet, and that's why we are registering people without qualifications in the managing agent field. And as soon as those qualifications are in place, then there will be time limits given for everybody who is a managing agent to become compliant with those requirements. For the moment, they are not. They're not required to have any qualification in order to register as a managing agent.
Just a follow up. So are we saying but do you also, so there's no qualification, but one has to have a FFC or can still operate without FFC as long as you're registered?
You can never operate without an FFC. I'm not with you. We register you and we give you an FFC because of the fact that you are registering and complying with the requirements to register yourself as an FFC, as a managing agent. But you get your FFC because of that. You can never ever operate without an FFC.
Okay, thank you for that. I have Ronel from the chat. When will managing agents need to submit on PPRA portal trust account audit?
Sorry, I just say that again. I didn't get it.
When will managing agents need to submit on the portal on trust account audit?
Oh, the same as everybody else. It's within 6 months of your financial year end. You submit your audit report.
Okay, thank you for that. I don't know, Luann, I think we addressed all the questions. I want to allow Ms. Vanida Moodley from NAMA to come through. I don't know, Advocate, you want to take the last two before I go to Ms. Moodley?
Sure.
Luann, please ask. We'll close with UKN as the last hand. Luann.
Thank you. So there was a couple. The one was, can you have the same trust account for your state agency as well as the managing agent? Can you operate it in one trust account?
Okay. As far as I know, the audit department requires you to have a separate trust account if you are a managing agent. Okay. But please, would you submit a question to audit@the ppra.org.za and ask them, and they will be able to tell you.
Okay, sure. Thank you. And then the other thing is currently as agents, estate agents, we work on referrals of property. So we kind of work together and work on a referral system, and I might refer somebody to KZN region being in Cape Town. That referral you mentioned earlier is a facilitator and intermediary function. Is it not an FFC function anymore than those referral payments?
How do you mean it's not an FFC function?
So as an FFC holder, I might refer a client to an estate agent in KZN, and I'm in Cape Town, and then get a referral fee as an estate agent.
Right.
Is that referral fee now considered a facilitator intermediary fee rather than a estate agent in the old terms referral fees?
It could be, but remember your facilitators have to also have FFCs. They have to be registered in their own industry, and they have to have FFCs. If you're doing it as part of your estate agent work, remember that part of the things you can do is part of, as an estate agent, you obviously will network and do those kinds of things. So in most instances, it would fall within your estate agent category. But if you were doing referrals apart from an estate agent business, you are not registered as an estate agent, and you are simply referring to estate agents, you not being able to assist them in any way. You might need to register as a referral intermediary or somebody of that nature in that particular industry.
Yeah, okay. And what about the CPDs then, Deborah? The CPD, I think the year that they started, and what is the starting year of them, and how many years? Because I know that's part of the legislation that you have to be up to date with your CPD to get your licensing. So what is the starting year of those CPD? Because I originally understood if your license was registered, say, in the middle of 2022, then your CPD years would start from the following year. Is that correct? Or maybe you can give us some guidance, please.
Yes, that's correct. Yeah, you start from the following year, yes.
Start from the following year. Okay. All right, amazing. That's my questions. Thank you so much for your time and for the presentation.
Thank you.
Okay, thank you. Let me take the last hand, UKN.
Hello. Hi.
Yes, we can hear you. Please go ahead.
My question I put down in the chat if we are the originator, can we pay the estate agent incentives? If yes, should it be in percentage or rand value?
Can it be
Sorry,
in,
you're what? Are you a bond originator or what?
Yes. Correct.
Okay, so you're a bond originator, and who do you act for? Do you act for the purchaser?
Yes, we act for the estate agent, and so also for the purchaser, correct? Are we allowed to pay incentives to the estate agents for business that they refer us, whether it be in a percentage format or whether it be in a rand value?
It depends on a number of things. I think the best thing to do is for you to just email me,
Okay.
and just put out the scenario that you're talking about exactly, and then I'll discuss it with you then.
Okay.
Naledi, will you just I don't know if you want me to give you my email address, or
No, it's
otherwise you
fine.
can
I've
send it
put
to
my
Naledi.
email.
Okay,
I put
send
my
it to
email on the
Naledi.
pin. Yes.
Yes, send it to Naledi and she'll send it to me.
Okay. Thank you.
Yeah. Thank you. Ntlantla says, Non-Ntlantla says, advocate, do interior designers require FFC registration to do work on properties?
No.
Okay, Non-Ntlantla, there's the answer. Colleagues, if there's a question maybe I missed, I do apologize. I'm really trying to see who we answered, because most of the questions, because they're similar, you will see I will not read it out because it's more or less the same question. It's either the answer was addressed in the slides or the answer was addressed when other colleagues were asking the same questions. So you would see that it would be answered so that we don't repeat the same question and the same answers. So we allow others. If you remember a question after the webinar, my email is on the pin. You can email us if you have an email you want to ask Advocate Val. I'll still ask her the questions on email, and she will reply everyone, even after the webinar, even days after. And those who have queries or you've logged a query on the portal, it will give you a reference number. When you follow up with the same reference. Yes, Advocate.
Sorry, I lost you. It's okay. I can hear you now.
Can you hear me now?
Yes.
Okay, no, it's fine because we finished with the questions. So the queries that you have, my email address, it's pinned there. Please send me your query. Let me follow up with the department, whether it's audit, I will send it to the audit department, or registrations or renewal, and we will see what could be the issue. But also, colleagues, I want to say, we also have adjudications and mediation and disciplinary department. We also receive complaints from consumers outside against property practitioners. And because they also have their own processes, sometimes you'll be asking yourself why your application is not going through, or maybe you might be blocked by that department because they would still need to investigate the complaint. And when you're receiving letters from those departments, try to answer them within those days, 21 days, 30 days, because they must hear both sides of the stories, before they can proceed to anything. A complaint doesn't necessarily mean the property practitioner is guilty or not guilty. They have to hear both sides. So there's a lot of factors and issues. I hear the frustrations, but I think email me. Let's find out what could be the hold up on your applications, why you're not receiving the applications, especially for those who are saying 2 years or 1 year. We really need to prioritize those and look at them and see what could be the issue. Luan, you have my email address. We've spoken before on email. I think some of the questions that you have, maybe let's address them. If you need a meeting, come to our offices. They're willing to meet with you and sit with you, our registrations officer and the reg manager, to see what could be the issue and if documents you are submitting them correctly the way that it's required in the Act and the regulations. Let me go to Ms. Vanida Moodley, Regional Coordinator from NAMA. If you can say a word or two before we can close, because these coordinations with managing agents, it was made possible because of NAMA. Please unmute. Thank you.
Hi, thank you, Naledi, for organizing this, and I must say it was very informative. Thank you, Advocate Deborah Weil, for availing yourself We really appreciate it. And I think most of the questions that we had were answered. So we appreciate it, and we thank you that we can also just get in contact with you should we have any further queries or so. So thank you once again.
It's our pleasure. Thank you.
Yes, no, thank you for that. The slides, I'm going to email everyone who attended the webinar, and I'm going to put the recorder on our PPRA TV channel. Within 48 hours, our marketing team, they will publish it there. Thank you to everyone who joined today, especially Advocate Vile, for just presenting this topic on managing agent registration and deregistration. We appreciate your time, the engagements, the question raised during the session. And we also want to thank NAMA for this. Let's continue the relationships to assist, your members, even those who are not your members, who are managing agents, to be compliant. Please keep an eye on our communication platforms for upcoming webinars. We're going to be presenting soon on evictions, code of conduct, and other topics that we need to bring in so that you stay updated with the regulatory information within the space. So colleagues, I will answer everyone on the chat. I see your email addresses. I'm going to CC you as well so that you get the slides. Advocate Ms. Moodley, thank you so much. Until next time, stay compliant, stay informed, and have a great day, everyone. Goodbye.
Thank you. Bye.
Thank you. Bye-bye.
Bye-bye.
Thank you.